Hello everyone. Social reformation is not a one-day concept. एक ही दिन में नहीं होता. It takes a lot of time to happen. For example, till 1829 we thought that sati is actually a prestigious thing, a prestigious cult. Before Ram Mohan Roy, nobody actually thought to abolish this system. In fact, Ram Mohan Roy told that sati system is a cult and it is not encouraged by any scriptures. Same applies to triple talaq. If you take the very nature of Muslim marriages are a kind of contract where in front of the Qaji and the elderly persons of the community, both the bride and groom share their mutual consent by speaking Kubul hai. Triple talaq is a concept by which Muslim marriages get dissolved. According to Muslim law, Muslim marriages can be dissolved in 4 ways. The dissolution by the consent of the husband with the help of the wife, mutual consent, and through a judicial process. Under the Muslim law, talaq could be of 2 major categories. Talaq-e-sunnat, S-U-N-N-A-T, Talaq-e-sunnat or Talaq-e-biddat. Talaq-e-sunnat, the root word sunnah refers to tradition. So talaq-e-sunnat means any type of talaq which has been going on for a very long time, or it is a traditional form of talaq. Under talaq-e-sunnat there are 2 subclasses. One is talaq-e-ahsan and talaq-e-hasan. Talaq-e-ahsan, in this the husband pronounces talaq and for 90 days the husband and wife remain separated. Within these 90 days, if at all there is any kind of mutual arbitration, or if they come together, they start to cohabit, then the talaq can be revoked. So there is a 90-day scope in case of talaq-e-ahsan. Same also applies in case of talaq-e-hasan. But in talaq-e-hasan, this talaq announcement is done in 3 stages. First month, the husband announces talaq once. In the second month, once more, and for the third time, another time, or once more. In this way also, the wife or the husband gave 90 days for any type of reconciliation or arbitration of the dispute. If they come together within this period of time, then the talaq can be revoked. As you can see that in both of the cases, ample scope is given, both in case of talaq-e-ahsan and talaq-e-hasan, so that the husband and wife can get reunited. So both talaq-e-ahsan and talaq-e-ahsan and hasan are good forms of talaq. In fact, the best is actually talaq-e-ahsan, because here 90 days of scope is given. Then talaq-e-hasan is also fine, because in 3 successive attempts, 30 days, 30 days and 30 days, 90 days scope is given. But now coming to the third form, rather the major category called as talaq-e-biddat, B-I-D-D-A-T. Talaq-e-biddat. Talaq-e-biddat means any form of innovation in talaq. Alright, any form of innovation in talaq. That means if I try to give talaq in a non-traditional way, I can write an email, I can give a WhatsApp text, I can make a call and announce triple talaq, 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 talaq 3 times. That is considered as talaq-e-biddat, which is a modern practice. Now, if we see that in this case the wife is not getting a scope, the husband and wife do not get a scope or time period to mutually arbitrate upon their relationship. So this is actually the worst form of talaq as such. Now in India, definitely this type of talaq or talaq-e-biddat has been criticized. But many other Muslim dominated countries in the world like Morocco, Algeria or Tunisia, in Turkey, in Cyprus, in Pakistan, in India, Bangladesh and other countries like Jordan, Iraq, Qatar, Indonesia, this form of talaq is actually highly criticized. Talaq-e-biddat is criticized. So on the issue of triple talaq, Supreme Court has recently given a landmark judgment. The case is famously known as Saira Bano versus Union of India. In this case, the petitioner was Saira Bano. Now, brief facts about the case. Saira Bano, a Muslim lady, was married to Rijman Ahmad, and their marriage had lasted for 15 years. And after 15 years, Rizwan Ahmad announces triple talaq, that is Talaq-e-Biddat, in front of Saira Bano. So Saira Bano in return files a kind of writ petition or a petition before the Supreme Court, where she challenges three Muslim practices. The three Muslim practices what she challenged, first one was triple talaq, okay, or Talaq-e-Biddat. Secondly, she also challenged polygamy, and thirdly, nikah-e-halala. Nikah-e-halala is a kind of practice in which if a divorced woman at any point of time wants to remarry her first husband or remarry her husband, then she is not directly allowed to have the nikah or the marriage. First, the woman has to marry another person, right? There has to be a second husband for the woman, and then she has to take the divorce, okay, from the second husband and get married to the first husband. So this is what is nikah-e-halala is all about. Now this is something what she challenged. Thirdly, under Muslim law, men are allowed to have polygamy, that means many women as their wives. So this was also challenged before the Supreme Court. The Supreme Court decided the case in 2017 with a 5 judges members bench. The honorable judges who constituted the bench were actually 5. So now who were there? First of all, Chief Justice of India Jagdish Kehar, Justice Abdul Nazir, Justice Kurian Joseph, Justice Rohinton Nariman, Justice J.U. Lalit. I repeat again, Chief Justice Jagdish Kehar, Khehar, Justice Abdul Nazir, Nazer, Justice Kurian Joseph, Kurian, Kurian Joseph, Joseph, Jagdish Rohinton Nariman, Rohinton Rohinton, Nariman Nariman, and lastly Justice U. Lalit. So these 5 judges constituted the bench to decide on the case of triple talaq. In the famous Saira Bano case, the petitioner was Saira Bano herself, and on the respondent side, along with Rizwan Ahmad, the husband of Saira Bano, other parties to the case were the Union of India, secondly, Ministry of Law and Justice, third, Ministry of Women and Child Development, Ministry of Minority Affairs, National Commission for Women, and All India Muslim Personal Law Board. So these were the respondent side. Again I repeat, Union of India, along with Rizwan Ahmad obviously, Union of India, Ministry of Law and Justice, Ministry of Women and Child Development, Ministry of Minority Affairs, National Commission for Women, and finally All India Muslim Law Personal Law Board, Muslim Personal Law Board. So these were the people, these were the respondent side. So in the case, first Supreme Court invited written statement from all the respondents so that they can present their point of view in writing. All India Muslim Personal Law Board said that all the 3 issues which are presented by the petitioner Saira Bano in her petition are outside the purview of the Muslim law, outside the purview of the Supreme Court's jurisdiction. They are internal matters of the Muslim law. That means Supreme Court has no right to interfere into the religious affair, personal affair, as mentioned in the cases of the petition. But Supreme Court, after listening and receiving all the written statement, decided upon some issues. They found out some issues which need to be addressed. If you remember in Sabrimala case, as you remember, in the Ayyappa Swami temple, the women were not allowed to enter into the temple in the age of puberty or menstruating age. For example, women starting from 10 years to 50 years were not allowed. Supreme Court actually decided this case on the basis by checking that whether it is an essential religious practice. So the first issue that the Supreme Court had to decide is to check whether such practice is an essential religious practice. Because if it is an essential religious practice, then Supreme Court has no right to interfere into this matter. So in Sabrimala it was decided that not allowing women of the menstruating age is not an essential practice, so it can be done away with. In the same manner, in this case of triple talaq or Saira Bano case, Supreme Court also wanted to decide whether it is an essential religious practice or not. If any practice is actually not an essential religious practice, then Supreme Court either can add, alter, deduct or maybe repeal such a kind of practice. Now the second issue that was before the Supreme Court that the Supreme Court judges decided was whether triple talaq system is violative of the fundamental right as given in Indian Constitution or not. So these two issues were adjudicated in the court. So thus we see there were two issues. First issue was whether it is violative of the fundamental rights or not. Second issue was whether such a practice of talaq-e-biddat is a part of essential principles of Muslim religion or not. Now different judges in the bench had different opinion. We will try to see what are the different opinion given by different groups of judges. First, coming to Chief Justice Honorable Justice Jagdish Keher. Along with him was Justice Abdul Nazir. So Justice Keher and Justice Nazir say that instant triple talaq or talaq-e-biddat is in the purview of Muslim personal law. Now Muslim personal law, which is basically religious law, is protected under the Constitution Article number 25. So the judiciary is not allowed to make any law in this regard in the course of its judgment. The right to such a judgment is given, right to take such a decision is given or handed over only to the Parliament. So Justice Keher and Justice Nazir told that let's have a stay on triple talaq for 6 months. Okay, so in this 6 months, let the Parliament decide whether triple talaq is a valid practice or not through a parliamentary process, a constituent process. Another group of judges, they were Justice Rohington Nariman and Justice U. Lalit. They together had a different opinion. According to them, triple talaq petition, whatever was filed in Saira Bano case, was not filed under Article 13 of the Constitution. Yes, it is right that under Article 13 religious practices are protected and they cannot be challenged in the court. But Saira Bano petition came under Article 14, 15, 21 and 25 of Indian Constitution. So they can be very well considered. Besides, they also told that any law which we are making, any practice which we are making before we make a constitution or after we make a constitution, they must be inconsistent with the fundamental rights. So fundamental rights, if they are violated, then definitely there is something where judiciary can interfere. As per Article 14, if any practice is arbitrary, if it violates the fundamental rights of any group or ethnicity, then it will be considered as arbitrary. So Article 14 protects arbitrariness of any practice. Now according to the judges, triple talaq practice, a talaq-e-biddat, is actually a violation of Article 14. Simultaneously, it also disregarded the rights of the women, their dignity of a woman. So according to them, under Article 14, if we impose the power, then automatically talaq-e-biddat or triple talaq becomes constitutionally invalid. Such a practice should be abrogated, rejected. But then the fifth judge was Justice Kurian Joseph. Justice Joseph Kurian held of the opinion that triple talaq or talaq-e-biddat or instant triple talaq is actually is violative. It is unconstitutional. Now, why did he say it to be unconstitutional? Because there are two fundamental principles which opportunities which is not given to the party who are going for talaq. That is the opportunity to discuss for arbitration and reconciliation. Since there is no opportunity in ITT, instant triple talaq, then it is un-Islamic, because most of the Islamic practices which have been traditionally going on give adequate opportunity of mutual discussion and conciliation. So according to Justice Joseph Kurian, this is actually un-Islamic in nature. So if we summarize the opinion of the judges, two judges were of opinion that court has no right to interfere into the matters of Muslim personal law, and instant triple talaq comes under Muslim personal law. On this, judges cannot take any decision, rather Parliament can bring any type of modification. Two judges were of opinion that Article 14, 15, 21 and 25 are violated. For the purposes of instant triple talaq, it is against the equality, it is gender injustice, and it is unconstitutional. And fifth judge, he was of opinion that this is also illegal or unconstitutional, because when instant triple talaq is applied, it does not give adequate amount of opportunity for arbitration and conciliation, which is fundamental to Islamic practices or Islamic law. So in this way, out of 5 judges, 3 were against instant triple talaq and 2 were in support of triple talaq, who opined that there should be a stay and the Parliament should make a law. So Supreme Court, in a majority, they declared this to be unconstitutional and invalid, and they directed the Parliament to make a law in connection to this. So after this verdict of the Honorable Supreme Court, what were the legal developments? In August 2017, the Honorable Supreme Court declared triple talaq as illegal, and there were many reported cases where triple talaq, where the ordinances or the directive given by Supreme Court was violated. The cases also raised in terms of triple talaq. Probably a community was trying to resist it. Well, in December 2017, Lok Sabha passed a bill called as Muslim Protection of Rights on Marriage Bill. Muslim Protection of Right on Marriages Bill. Now, this bill actually, although it was passed by Lok Sabha, it got held up in Rajya Sabha and it lapses. Okay, and then in September 2018, Cabinet clears an ordinance. So we remember that in December 2017, there was this bill called as Lok Sabha which passes, called as Muslim Protection Rights on Marriage Bill 2017. This was passed from Lok Sabha, but it lapsed due to not having the support of Rajya Sabha. In September 2018, Cabinet issues an ordinance looking at the social condition. Here, triple talaq or instant triple talaq was considered to be an offense, and punishment of imprisonment. The punishment was actually 3 years of imprisonment. And finally, in July 2019, Lok Sabha and Rajya Sabha both passed the bill, and both the houses give assent to the bill. President also gives his assent to the bill against triple talaq. So according to the recent bill passed, that is Muslim Women Protection of Rights on Marriage, Muslim Women Protection of Rights on Marriage Act 2019. According to this act, triple talaq or instant triple talaq, whether in written or in electronic form, is to be void in law and is illegal. That means it has no force. It is also illegal. That means it declares itself as an offense. In this act, triple talaq is a cognizable offense. Cognizable offense means an offense where a police can arrest the person without even a warrant. So it is a cognizable offense, and the maximum period of imprisonment could be 3 years plus fine, as depending upon the merits and the decision of the judges. Now, in this way, the Muslim Women Protections of Right on Marriage Act 2019 declares triple talaq to be illegal and void. Another important provision in this act is that only the wife, that is the married woman, against whom the talaq has been declared, she can file the complaint. So, apart from the woman herself, any person who is related to her by blood or any person who is related to her by marriage can file the case on her behalf if the woman is unwilling to do so or unable to do so. This bill provides bail, but the magistrate can give a bail after listening to the woman if he finds that there are just and reasonable causes for granting the bail. So, hearing of the woman aggrieved by triple talaq is compulsory as per the act. Apart from that, this act also provides provisions related to allowance and custody. The woman is entitled to seek subsistence allowance for herself and her dependent children. Subsistence allowance means the minimum amount of allowance or money that a woman requires for managing herself. For herself and also for her dependent children, she can ask for subsistence allowance. Similarly, the man, if he is jailed, also has to look for the allowances for the wife and the dependent children. The woman also can seek, or she is entitled to seek, the custody of her minor children. She can take the custody of the minor children. So in summary, we can say that the development which started from 2016, the reformation which started in 2016, in 2019 it has ended in the form of a statutory act. In this statutory act, instant triple talaq or triple talaq is considered to be a cognizable offense. It is criminalized. Now, we also have to think that if there is any long-term implication of such type of criminalization or not. Thank you. Have a good time.